Good day, Crime Talk aficionados. We have a great show for you today. First, the lead investigator in the Karen Reed case has been fired. What does it do to the case against Karen Reed? Oh, and Karen Reed wants a continuance, and apparently the prosecution's okay with that. Further analysis of the Luigi Mangione motions to suppress. A family man politician gets arrested for, wait for it, should kids get a pass for murder? We have a story about a teacher gone wild, and do I mean wild? Charges dismissed against a man for allegedly killing his wife because the statute of limitation runs out on the prosecution. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and remember, you can check us out on any of your favorite podcasting apps as well. All right, before we get to the docket, remember to go to crimetalksearch.com where you can sign up for that background subscription service today. When you do, you'll be able to do as many background searches as you desire on anyone here in the United States. And literally, the report is not only completed while you wait, it is emailed to you, and you can even get updates if information changes. And it's going to have information about telephone numbers, email addresses, social media presence, whether somebody has a criminal history, whether they're married, divorced, has judgments or liens against them. Go to crimetalksearch.com and check that person out. The one that's coming into your life, maybe one you're not getting those warm, fuzzy feelings from, and maybe they need to get out of your life. Go to crimetalksearch.com, check it out. You're going to be happy that you did. All right, let's go ahead and open the record for Wednesday, March 19th, 2025. And yes, we start off with more Karen Reed news. Now, for the Karen Reed camp that thinks she can do no wrong or her attorneys can do no wrong, I think we're going to go pretty light on Karen Reed today. Now, I don't have anything against Karen Reed. We just call it the way it is. Some people, if you want to go to their channel, it's Karen Reed can do no wrong all day, all the time, or Karen Reed is guilty all day, all the day, all long, all the time. And you can go to those channels. We just give it to you the way we see it. Here's the facts. Here's the analysis. Take it for what you want. But man, I don't think I've seen a group of followers to a case that are this devoted to Karen Reed. I get it. There's some irregularities that went on in the case. I've said it, that I would have voted her not guilty based upon the presentation of the evidence or the lack thereof in the first trial. But some of the things that have taken place, and I've said it never goes better for the defense second time around. I'm standing by that. All right. I wish her well. We give her the presumption of innocence. But man, you people are very almost combative. You just, well, what about this? Sure, her attorney lied and the judge found that she lied, but you know, the prosecution failed to turn stuff over too. Okay, I get it. I deal with that crap all the time, ladies and gentlemen. I just don't understand. Why are you all shocked when the guy that you think's guilty, that stuff takes place and nobody ever says a damn word about it? That's all I'm saying. All right. We give you the facts. We give the analysis. I don't have any dog in the fight one way or the other. So the Karen Reed people that think she can do no wrong, we're just going to give you the facts. And if you don't like it, hey, that's okay too. Do with it what you want. Anyway, like I said, the cop who called Karen Reed a whack job, and another word that rhymes with punt in text messages to his buddies, has been fired from the Massachusetts State Police. Now, Trooper Michael Proctor, the former lead investigator in Reed's alleged murder of her police officer boyfriend, John O'Keefe, was fired from his job officially after he admittedly engaged in unprofessional messages that were revealed at Karen Reed's trial last year. Now, Mr. Proctor's family claimed the 12-year veteran trooper had been wrongfully terminated and defamed, and it was not immediately clear if Mr. Proctor planned to bring a legal action to get his job back. A statement that was put out said, quote, Proctor and his detectives led a meticulous and thorough investigation of integrity, and despite today's wrongful termination and great harm and defamation this case has inflicted on him and his family, Proctor still believes justice will be served. The family family put in their statement, end quote. Now, during Reed's first trial, Mr. Proctor was forced to answer some embarrassing correspondence about his investigation target, Miss Reed. Mr. Proctor joked about searching for nudes on Reed's phone and made fun of her Crohn's disease, saying she's got a leaky balloon knot, leaks poo. He also seemed to have made up his mind about Reed's guilt when he texted, quote, "I looked at O'Keefe's body in the hospital. He was banged up. She hit him with her car," end quote. Proctor called her retarded and said he truly hated her lawyer, calling the attorney asshole. Anyway, Proctor admitted from the witness stand that the messages were regrettable and something that he is now not proud of, that he was actually faced with them. Anyway, Mr. Proctor was suspended without pay the week after Reed's case, ending in a mistrial in July because of a deadlocked jury. Now, his family has insisted that the messages show he's only human and that they were on his personal phone to friends and family, and forgivable responses to a beloved fellow police officer who had been murdered. As you all know, Miss Reed faces a retrial that's supposed to begin on April 1st in the case where Miss Reed is accused of running over her former boyfriend, Officer O'Keefe, with her little SUV after a night of drinking and leaving him for dead in the snow. Now, Reed has maintained her innocence and claimed that she is a scapegoat of a sweeping law enforcement conspiracy and cover-up. Now, the feds looked into these allegations to see if there was any possible law enforcement misconduct, but the feds closed their investigation earlier this month without any charges. So while we're talking about disciplinary reports, instead of just giving you a quick recap or a speculation as to what took place, let's read the trial board's finding. So it's Department of State Police Personnel Order. The findings of the trial board held on January 15th, 2025, February 10th, 2025, March 13th, 2025, in pursuance of the personnel order, and it goes on and lists the case number, dated January 6th, 2025, having been approved by the Colonel Superintendent Trooper Michael D. Proctor, is hereby found as it relates to Charge 1, Specification 1, 2, and 3, guilty, guilty, guilty. Charge 2, Specification 1, guilty. Trooper Proctor, on various dates between January 29th, 2022 and August 17th, 2022, did fail to conform to the work standards established for the member's rank, title, or position, and or did fail to take appropriate action on the occasion of a crime, disorder, or other condition deserving state police attention. This occurred when Trooper Proctor, while assigned as the lead investigator in a homicide investigation, sent derogatory, defamatory, disparaging, and or otherwise inappropriate text messages about a suspect in that investigation to another individual. This action is in direct violation of Article 5.8.2. This is a Class A violation. Trooper Proctor, on various dates between January 29th, 2022 and June 9th, 2022, did fail to conform to the work standards established for the member's rank, title, or position, and or did fail to take appropriate action on the occasion of a crime, disorder, or other condition deserving state police attention. This occurred when Trooper Proctor, while assigned as the lead investigator in a homicide investigation, provided sensitive and or confidential information about a homicide victim, potential witness, and or potential investigative steps in the investigation to non-law enforcement personnel. This is a direct violation of Article 5.82. This is a Class A violation. Trooper Proctor, through his actions on various dates between January 29th and 2022 and August 17th, 2022, did fail to conform to those work standards and did fail to take the appropriate action on the occasion of a crime, disorder, or other condition deserving the state police attention. This occurred when Trooper Proctor, when assigned to the lead investigator in a homicide investigation, through his unprofessional and inappropriate conduct, created an image that was biased in his dealings with a homicide suspect and or brought otherwise himself and Massachusetts State Police into disrepute. This is in violation of Article 5.8.2. And Trooper Proctor, on July 19th, 2022 did consume alcohol while on duty and not in the performance of duty, and while acting under specific orders from a supervisory member or proper authority. This occurred when Trooper Proctor consumed alcoholic beverages while eating dinner on duty and then proceeded to operate his department-issued cruiser. This is in violation of Article 5.10.4. So there you go. Proctor made his inappropriate statements that we just talked about. One of the bases for getting him fired, and then drinking on duty and driving. The irony of it all, isn't it not? Yes, it is. What can you say? Next, the Karen Reed legal defense team is asking to push the second trial back more than 3 weeks to allow time for their federal appeal to run its course. Delaying the trial from April 1 through April 25 is apparently necessary to permit Ms. Reed to appeal the denial of her federal double jeopardy claims, which the federal district court expressly found to be substantial to the First Circuit Court of Appeals prior to being forced to undergo a retrial that Ms. Reed contends would violate her rights. Now, that motion that was filed today, signed by her 5 attorneys, states that the filing asked for on or before April 25th, but not later than April 28th or the first available dates thereafter for trial to start. So they want to delay it a month. The federal appeal is the latest effort to have her case, at least have 2 of the 3 charges against her thrown out after the defense says 5 jurors contacted them after last year's mistrial to say they were only hung on the manslaughter charge and were ready to acquit on the other 2. They first took the double jeopardy protection claims, which is the right for a defendant not to be retried on crimes for which they were already acquitted, to be tossed out by the judge, who denied that, the trial court judge. Then the Massachusetts Supreme Judicial Court upheld the trial court's ruling, and then the Boston-based federal court, Judge F. Dennis Saylor, denied the defendant's request on habeas corpus grounds, and the current matter is on appeal of the federal judge's ruling. The latest filing states that the U.S. Supreme Court noted in 1977 in the case of Abney v. United States that the rights conferred on a criminal accused by the double jeopardy clause would be significantly undermined if appellate review of the double jeopardy claim were postponed until after conviction and sentencing. It is a guarantee against being twice put on trial for the same offense. The filing says the prosecutors agree to a continuance of the trial to the end of April of next month and here in 2025, but that the prosecution reserves the right to oppose any further continuance or delay of the trial, including if the First Circuit appeals has not been resolved by the time of the new trial date. Now, I get it. I thought this double jeopardy argument was a loser from the beginning. This is Law School 101. Jeopardy attaches when you're actually acquitted. There was no not guilty entered on the record. Blame the attorneys, both the prosecution and the defense and the judge, for not inquiring. Have you been able to reach a verdict on any of those counts? They didn't ask. Nobody asked. That means it's waived. There was no not guilty entered. Doesn't matter. And it would have to be unanimous. 5 jurors isn't enough. It's been denied at every juncture. Trial court, Supreme Court in Massachusetts, the federal court, district court denied it. And now the federal appellate courts for the First Circuit are going to deny it. It's a loser. Move on. Let's start this thing April 1st. Let's do it. And guess what? Karen Reed's defense team has filed their list of prospective witnesses. Now remember, the defense, just like the prosecution, you have to endorse people that you may call, but you don't have to call them. But the defense team lists 91 names as prospective witnesses that the defense may call to stand trial. Now, the defense has filed a disclosure for their witness list. Now, remember, you have to endorse who you may call. You don't have to call them. In this particular case, the defense has listed 91 prospective witnesses that the defense may call at the Karen Reed trial. Are they going to call 91 witnesses? No, that's ridiculous. It's not going to happen, ladies and gentlemen. They've listed everybody that's ever been endorsed in the case, and in the chance that they may need them, I get it. They're doing what they have to do. But let's be realistic. I would ask, if I was the prosecutor, and the judge may do so as well, okay, that's nice. Now give me your good faith witness list who you really intend to call. Obviously, it's subject to change. The defense never has to prove anything, but who are you really intending to call? Anyway, the list includes a lot of familiar names from the first trial, members of the Albert and McCabe families. Brian Higgins and Kenny Roberts are all listed. The district attorney, Michael Morrissey, is also named as the former Massachusetts State Trooper, Michael Proctor. We're just going to have to wait and see how things work out in the Karen Reed case. Does it affect anything really that Proctor got fired for making some inappropriate comments? Is the prosecution still going to call him? Yes. Will they probably address it? Sir, have you been fired? Did you make some inappropriate statements? Yes, I did. I regret it. It actually cost you your job. Yeah, but is that going to affect anything as it relates to what you testify here to today? Do you tend to tell the truth? Yes, I do. That's what the prosecution is going to ask him. On cross-examination, sir, isn't it true you only looked at Karen Reed? You concluded that she was the only suspect, and you built the case around her when you know the police beat up and killed Officer O'Keefe. Isn't that true? No, sir, that's not what I believe. And that's it. It's a couple of questions. Now, would he be a little bitter, the fact that he, got fired? Yeah. Does he maybe want to just be done with this? Absolutely. Or maybe he's a little vindictive at this point, thinking Karen Reed got me fired. Like, oh, I'm going to get you. I don't know. It's going to be interesting. We're definitely going to have to wait and see. Next on the docket, a little more analysis of the Luigi Mangione motions. So Luigi Mangione's court date got moved to next month as his lawyers want to challenge the evidence as it relates to his arrest. Luigi Mangione, accused of killing a CEO of the United Healthcare, was scheduled to appear in federal court today in New York City, but his hearing has been pushed back to next month. Meanwhile, his legal team in both New York and Pennsylvania claim his rights were violated when they arrested Mr. Mangione back in December, and they say that he wasn't advised of his rights under Miranda, and his DNA was collected illegally when he was given a snack and a drink. Now, Luigi Mangione's next court date in federal court is going to be scheduled for April 18th, followed by the state court. But Mangione has pled not guilty to the murder, terrorism, and other charges related to the December 4th killing of Mr. Thompson. Now, obviously, the shooting prompted a 5-day manhunt for Mr. Mangione, leading to his arrest in Pennsylvania, where police said he was found with a backpack containing a gun that matched the murder weapon, a notebook that had some writings in it critical to the case, and the judge set April 9th deadline for the defense to submit pretrial motions and gave prosecutors until May 14th in which to respond. Now, the judge is expected to rule on those motions on June 26th, and there's going to have be an evidentiary hearing since a motion to suppress was filed, which alleges that the search and arrest of Mr. Mangione was illegal. The burden then shifts to the prosecution to prove by clear and convincing evidence that it was not illegal or some exception to the warrantless arrest requirement was made. But the defense is trying to completely tear down, dismantle the case on these grounds, right? We've talked about this, motions in limine. What motions are bad for me? Motions to suppress. What evidence do I need to get rid of? That's what you do when you attack the case. So what the defense has done is they're beginning with asserting that Mr. Mangione was detained without probable cause, and that the officers approached him at this McDonald's and they prohibited his movement. Obviously, he's not free to go, then you're under arrest, and did not read him his rights before they began asking questions or collecting evidence. Now, if a person is arrested in most states, you're allowed to take non-intrusive swabs from somebody's cheeks. Not really where I am. You got to, when you get arrested, yes, they do it now for booking, and that can be destroyed if the case is ultimately dismissed. But anyway, that's true. Anyway, the use of the touch DNA is also acceptable. But in this particular case, the defense is questioning whether he was arrested before the DNA was taken. Anyway, the alleged errors took place allegedly in Pennsylvania, where Mangione was arrested at that McDonald's. And the question then is, how is that going to impact the case as it relates to New York and the federal charges if, for example, a judge finds that there was an illegal arrest, search, and seizure of Luigi Mangione? Well, some people say, well, it's going to blow up the whole case. Certainly, it would be persuasive to other judges, that another judge found that it was in violation of that, but it doesn't necessarily bind the federal court and the courts in New York as it relates to that. It was certainly a help. Don't get me wrong. People say, look, it was illegal. How can one judge find it illegal and another judge can't? Well, that's what happens. Judges are that way. And remember, the defense may have a great legal issue on motions, but your legal issue is only as good as the judge that it is in front of. I know judges that have never granted a motion to suppress in their life, and they never will. They always find a reason to say, yeah, that was reasonable. Officer safety, protect the officers, something along those lines. Okay? So I wouldn't get all excited just yet. All right? Anyway, so the moment of the arrest, that is the first time the suspect, Mr. Mangione, has been caught, and they're going to question everything from this anonymous call to the police, like we mentioned yesterday, right? If I call and say, hey, I'm an anonymous person, and there's a drunk driver driving a blue BMW down highway, I-25 at this mile marker, and then the police have to look and see if that anonymous information is credible. Right? They have to view the bad driving before they can pull somebody over. And that's kind of what they're saying here. It's an anonymous tip. How'd you know it was him? But the police can go up and ask somebody, hey, who are you? So, like I said, I'm a defense guy. I really, really am. But I got to be completely honest with you, just like I'd be honest with my client and say, hey, you probably got about a 30% chance of this motion prevailing in Pennsylvania. Just being realistic. Anyway, at this court hearing, they're going to question whether releasing the so-called manifesto also prejudiced the case in any way. And the defense is also looking to toss up every bit of evidence they can. And it looks like that's their strategy. Start in Pennsylvania and then move east to New York in both state and federal court. We'll see, ladies and gentlemen. I'm a defense guy. I don't trust the government when it comes to anything. But I also know the judges trust the cops to the nth degree. So we got to be realistic, okay? Just trying to lower those expectations a little bit. Next, a politician is arrested and trying to meet a minor for sex. Oops, that's right. A state senator, a Republican state senator, was arrested for allegedly soliciting a minor for prostitution in a sting. Oops. Please meet Justin Ikron. He's a 40-year-old guy, and he was caught up in Bloomington, Indiana the other day after he allegedly arranged to meet up with who he thought was going to be a minor, a 17-year-old girl, to have sex with her. Turns out, yeah, that's right. It was a Bloomington, Indiana police detective. Yeah, she's the one that met the married father of 4. Take a look at these guys' videos. He's Mr. Family Man. I'm Mr. Family Man doing all the right stuff. And apparently when he's not passing laws, making sure everybody, abides by those laws, he's out breaking them with children. Anyway, apparently the police say he was observed arriving in his pickup truck before being arrested without incident. So at least he cooperated. And the police chief said, hey, if you're a 40-year-old man and you come to the orange jumpsuit district looking to have sex with some child, you can expect that we're going to lock you up, said the police chief, Booker Hodges. Apparently, the state legislator was booked into the Bloomington Police Department jail and was transported to the Hennepin County Adult Detention Center. Felony charges of soliciting under 18 years of age for the practice of prostitution are pending against the good state senator. Anyway, Mr. Ekron, like I said, is a Republican senator elected back in 2016. He's from Grand Rapids and shares 4 children with his lovely wife, Brittany. Needless to say, the State House Republican leadership has called for their colleague to resign after the news of his arrest. Now, can you imagine, ladies and gentlemen, the ride home? Can you imagine the ride home when his wife bonds him out of jail? And saying, oh my gosh, you could be potentially a sex offender, soliciting prostitution. Imagine the ride home. Let me tell you a little story. I had a guy once, I got called years and years ago, called on a Saturday morning by a woman that was like, hey, my husband's been arrested. Can you help him out? Get him out of jail. Well, it's Saturday. I don't know. I mean, yeah, I guess I can get down there. I'll bring a fee agreement, sign, whatever. Anyway, that incident, we go, we meet, etc. And the wife had just one request of the judge. Would it be possible the car that was arrested and seized that the husband was soliciting prostitutes in Could we get the baby seats out of the car? Baby seats. It's got young children. Can you imagine that ride home, ladies and gentlemen? Oh, I would have loved to have been a fly on the interior of that car to see what was said. Ooh, and this guy was like a big muckety-muck executive. Imagine what the state rep was thinking as well. He probably wishes he was dead. Anyway, kids these days, and the reason why I bring you this story is I had a case like this on a post-conviction matter once where kids were out driving around, and they see somebody, and they said, look, 2 points if you leave his shoes in place. And they ran somebody over and literally left his shoes in place. I don't understand why kids think this is funny. I really don't. But we got a story about a case here. Just bump him, brah. That's what the kid said. That's what a 15-year-old boy could be heard on video saying to the driver of a stolen vehicle his 13-year-old buddy was driving. And then they drove down a street in Albuquerque, New Mexico, back in early May of last year when they approached a man riding a bike in the bike lane. And this kid's saying, like, bump him. Yeah, bump him. Go like 15, 20 miles an hour. The 15-year-old who sat in the back seat responded, according to the police. The 13-year-old boy allegedly accelerated the car towards the bicyclist, later identified as 63-year-old Scott Dwight Habermel, who was riding to work at the Sandia National Laboratory. Why? That's because he's a physicist. Anyway, as the kids approached Mr. Habermel, the front seat passenger, a 11-year-old boy, waved a handgun and started laughing when they hit the cyclist, according to police. They were loud sounds, including metal flexing, as the momentum of the crash carried Mr. Habermel and his bicycle on top of the car and off the passenger side as well. Needless to say, Habermel was killed and the boys drove away. Albuquerque police investigated the May 29 hit and run and were unable to determine those responsible until police received an anonymous tip last month that a video showing the incident was posted on an Instagram account. Police looked at the account. A middle school principal also contacted police to say a student had reported the video. It turned out that the police were already in possession of the phones of the 13 and 11-year-old boy from a separate unrelated investigation that was ongoing, and the detectives obtained a search warrant to examine the phones, and guess what they found in those social media accounts? That's right, the video and audio of the crash. Well, the two older boys will stand accused of murder, conspiracy to commit murder, leaving the scene of an accident involving great bodily harm or death, and unlawful possession of a handgun by a person. Cops say the 11-year-old boy is too young to be charged as an adult, and they are working with the prosecution to determine what charges that he may face. Like I said, Mr. Habermel worked as a physicist at the Sandia National Labs for 30 years. Now, the police did also note that the 13-year-old boy was in custody and they were looking for two other suspects. It's unclear if the other boys will be charged as an adult. Normally, most states allow anyone over the age of 14 to be tried as an adult. They should be. Anyone over 14, bring it on. Next, a teacher gone wild. And do I mean wild? Okay. A married teacher. All right. There's small children around. Let's just close your ears. All right. A married teacher asked 3 underage boys to, quote, gangbang her and ordered them to wear a scream mask while doing so, according to the arrest affidavit. Please meet 31-year-old Brittany Fortenberry. She is facing dozens of charges over the allegations made by her friend's son and other accusers. Victims have claimed that the teacher raped at least 10 underage boys, and the allegations come after the Indiana educator was charged with sexually assaulting a 15-year-old boy and sending him explicit messages, pictures, and videos to the high school student. Now, 5 more alleged victims emerge, resulting in a slew of additional counts being recommended against her and her husband, Nicholas, who police say was aware of the conduct. Now, Fortenberry's friends told detectives that her son had been groomed by the teacher, according to the arrest affidavit. The affidavit explains how Fortenberry allegedly showered the woman's son with expensive football gifts and tried to message him repeatedly on Snapchat until the boy's mom told him to block the teacher. She explained that her suspicions were aroused after details emerged of the original charges against Fortenberry stemming from her time at the high school where she taught. That prompted the mother to ask her son outright if anything had happened, according to the arrest affidavit. And the kid apparently began to cry and told her that Fortenberry had bombarded him with sexually explicit videos of herself and had provided him with drugs. What he suspected was alcohol as well. The boy told the detectives that Miss Fortenberry would always make him food and would buy him anything he wanted, including vapes, weed, and THC cartridges. Anyway, he made his claims about several instances where Miss Fortenberry allegedly plied him and his friends with mushroom pills before encouraging them to touch her sexually. Brittany would peer pressure them if they didn't want to take the shrooms, according to the affidavit. And Brittany, that's right, the teacher, would grab their arms, she would say, and just let it happen. His mom told the police that her son claimed that Brittany would put the shrooms on a peanut butter sandwich so they could taste better. The boy claimed there were once occasions where Miss Fortenberry picked him and two friends up and took them to the mall before calling their parents to ask if they could spend the night. If your teacher's asking for your student to spend the night, ladies and gentlemen, be afraid. Now, once there, the 13-year-old alleged that Miss Fortenberry ordered him and his two friends to begin having group sex with her, despite the youngsters all being underage. Well, Miss Fortenberry had one condition for them to have this little party, was that they had to wear a scream mask to, her, according to the arrest affidavit. That was a reference to, obviously, the famous black and white ghost face mask worn by the killers in the Scream series. Anyway, the boys also claimed that Miss Fortenberry told him she would pleasure herself over their school photos. His mom told the police that she had allegedly seen a video that Miss Fortenberry sent to her son in which she showered. The mom also told police that she had seen a video that Miss Fortenberry had sent her son of her, which showed her carrying out a sexual act with her son's boxer shorts. Now, the accuser additionally claimed that Miss Fortenberry's husband, Nicholas, was aware of the alleged abuse and threatened to slaughter him in front of his family if he ever spoke a word about it. Guess what? Brittany's husband knew about the things that were going on, according to the affidavit, and Brittany's husband talked to them about not telling anybody. Brittany told them afterwards that they better not tell anyone. Brittany's husband also told them to wait until they were 16, obviously knowing that something was taking place. Nicholas has since been charged with intimidation and failure to report a crime. And the allegations by the other three alleged victims are equally as graphic and contain similarities to the first boy's account. They all contain claims that Miss Fortenberry sent nude photographs and videos via social media, spent hundreds of dollars on weeds, vapes, and clothing and the alleged victims. And one child even claimed that he was sent topless photos of his teacher, who said she also allegedly showed off her sex toys and stripper pole in a series of obscene messages. Following her arrest, Miss Fortenberry told them that she regretted losing 150 pounds and would have acted differently if she was still heavier. She was immediately suspended from her role as a teacher last August and resigned the day later. I don't understand it, ladies and gentlemen. What has gotten into teachers, man? I don't know. I don't know. I just don't know what to say. But if a teacher is asking for your kids to spend the night, the 13-year-old to spend the night at the house, you need to go to crimetalksearch.com, search them, and then immediately call the police. That's not normal, ladies and gentlemen. Maybe the parents should get a little bit of a little trouble as well for not saying something. That's just weird. Next, you snooze, you lose. A man accused of killing his wife more than 10 years ago will not stand trial after a judge dismissed the charges, finding that the statute of limitations had expired. So at the 2024 trial, a jury found David Swift not guilty of first-degree premeditated murder of his wife, Karen Swift, but was unable to agree on a charge of voluntary manslaughter. 2 weeks after the mistrial on that count, David was reindicted on the charge of voluntary manslaughter. On Monday, the judge hearing the case ruled the statute of limitations had passed and that the prosecution had failed to commence their case within the acceptable period and dismissed the charges against David. The ruling orders him released from custody subject to any other outstanding warrants. A retrial was scheduled to start on May 7th. Now, his wife, Karen, was initially reported missing back in October 30th of 2011. Her car was found with a shredded tire near her home, and on December 10th, 2011, her body was found in an abandoned cemetery. Her cause of death was ruled blunt force injury of the head. David faced unrelated charges in Alabama for taking his second wife from whom she was divorced. Next on the docket, this day in legal history. On March 19th, 1734, Thomas McKean, a key figure in the American legal history, who later served as Chief Justice of Pennsylvania and signed the Declaration of Independence, was born. His judicial career helped shape early U.S. legal principles. On this date in 1815, the Battle of New Orleans officially ended, marking a significant military legal closure to the War of 1812, with implications of treaties and national sovereignty. On March 19th, 1918, Congress passed the Standard Time Act, establishing the time zone and daylight savings time, a legal framework impacting commerce and crime reporting consistency nationwide. On this day in 1931, Nevada legalized gambling, obviously a big shift that later influenced organized crime dynamics, particularly in Las Vegas. And on March 19th, 1982, the United States Supreme Court ruled in Eddings v. Oklahoma that a defendant's youth must be a mitigating factor when considering the death penalty, obviously reshaping capital punishment mitigation law. And then finally today, our dumb criminal of the day. The mayor of a town in New Jersey has been charged with driving under the influence, driving recklessly, and endangering a child. According to the police reports, a witness took video Monday of a driver unable to stay in their lane and nearly hitting a utility pole. Police located the car, and it turned out to be the home of Mayor Gina LaPlaca around 6 p.m., where she allegedly admitted to officers that she had been drinking a little bit and recently picked up her 2-year-old daughter from daycare. Court documents also say that an open container of alcohol was found in the car, and Miss LaPlaca's husband, I guess the first gentleman of the city, stated that she is now seeking treatment for addiction. Now, the mayor is scheduled to appear in court on April 28th. Mayor LaPlaca, you are our dumb criminal of the day. Don't drink and drive. And guess what? When you're in charge, you're a public servant. You're there to enforce the law. You have to do better and cleaner than everybody else. And when you don't, you fail. Guess what? You got to be called out on it. It's just the way it is. All right, ladies and gentlemen, that's all we have for you today. Thanks for watching. Hope you enjoyed the show. We'll see you next time. And remember, the Constitution matters.